I think Attorney General of New York, Leticia James, is Donald Trump's Freddy Krueger. I think she shows up in his nightmares. That's how much he hates her and is scared by her, and for good reason. Not only did she take a $465 million, now $500 million civil fraud judgment off him, but she's also brought a series of cases leading other attorneys general against his administration this time around and during when he was 45. And she's winning at a very high rate of a winning percentage. And now we have a brand new case that was just filed yesterday in the District of Massachusetts, assigned to a senior judge who was appointed by Reagan, if you can believe it. And this is a case in which they're trying to challenge the attempt by the Trump administration to cut off tens of billions of dollars of aid to federal schools. Federal aid to public schools, in this case, $14 billion worth, which the schools used and the districts used for things like special education, vulnerable and fragile populations within the school, people who don't speak English, English as a second language programs, good things. But Donald Trump, who's a hammer, everything is a DEI nail. It's DEI. These people are black and brown. They speak a different language. It's DEI. And within days of being able, before they ordered federal funding to be cut off, the Department of Education under Donald Trump and Linda McMahon sent a notice to all of these states that said, certify that you're not going to discriminate on the basis of diversity, equity, and inclusion, or we're going to cut off your federal funding. Diversity, equity, and inclusion is baked into the very essence of public education. How are they going to do that in a couple of days? Why would they have to do that? And how is that not a violation of constitutional principles and the Administrative Procedures Act, says the new lawsuit? I'm Michael Popok. You're here on Legal AF. I love the Leticia James, fresh off of some scurrilous claims against her that she committed mortgage fraud when that's a lie, in taking out a loan in New York and buying a piece of property in Virginia with her father. That's the way the Trump administration wants to try to tie her down and tear her down, just like they did Fani Willis in Georgia. What do they have in common? You be the judge. But here, she doesn't care. She said, that's BS. I got a job to do. So once again, she joined with 18 different states, and the states include New York, Massachusetts, Illinois, California, Wisconsin, you name it. It's all the blue attorneys general. And what they've said to the Judge William Young, senior status judge appointed way back in old-timey times by Ronald Reagan, which means he's not a Trumper. What they said to him is, all of this effort to cut off these tens of billions of dollars of aid last minute that schools use to service the underprivileged, right? To service the disadvantaged, to run school lunch programs, to run special education programs. I didn't realize that was a black versus red issue. Helping kids who are disadvantaged, that's a black versus red. I thought that was a red, white, and blue issue. And so I'm proud of the fact that she's filed. Now, the reason some people might be thinking, why did they file in Massachusetts? Okay. Just as the Republicans and MAGA like to file in places like Louisiana and Texas and Georgia and Florida, the moderates and the Democrats and all, we file in the original 13 colonies, primarily in New England, Massachusetts, and New Hampshire, and then we flip over to California. These are and DC and Maryland. These are the places we go because the judges there are moderate. They are independent. Some of them are Democrats and all of that. So that's why there are so many cases that I report on that are filed in the District of Massachusetts. And also the appellate court there, the First Circuit, also leans liberal. It's like a lot of Vermont, New Hampshire, Maine, Massachusetts people. And so that is more Democrat and more blue. So you get a good trial judge, and it's a Republican here. You get a very good First Circuit Court of Appeals, which is presided over by one of the Supreme Court justices that are moderate or liberal, and then you're on your way to the United States Supreme Court. It's a good place to set it up. But New York is leading this case, and so is Leticia James. Let me read to you from a couple of paragraphs so you know what this case is about. This is from the complaint seeking an injunctive relief. Yes, we're on the path to yet another injunctive relief. Lawsuits, we're pushing almost 200 lawsuits against the Trump administration. Over 60, almost 70 injunctions have been issued against the Trump administration, and he's now got a losing record at the United States Supreme Court. You do the math. Here we go. Each year, this is paragraph 1, the United States Department of Education, that's federal, provides states with billions of dollars of congressionally mandated financial support. That's very important. Congress controls the purse strings. Congress allocates what money and directs it through federal programs by Congress. This attempt by the Trump administration through its Department of Education, which is supposed to be faithfully executing the laws of Congress and the funding of Congress, is nothing more than them legislating from the executive branch. And that is a violation of the spending clause, of the separation of powers clause, and the rest. The appropriations clause. The money sits with Congress, not with the executive branch. The reason the executive branch and Trump is taking advantage of the fact that they control Congress effectively, and it's a doormat, and it's a limp noodle. So they just are, well, we'll do it ourselves with our executive orders. Yeah, that's not how that works. Until a federal judge tells you you violated the law and the Constitution. So you've got this federal, congressionally mandated financial support to critical programs and services, including ensuring that students from low-income families have the same access to high-quality education as their peers, providing special education services and accommodations, recruiting and training highly skilled and dedicated teachers, funding programming for non-native speakers to learn English, and providing support to vulnerable children in foster care and without housing. This is a red versus blue issue? I don't think so. Defendants have acted unlawfully to imperil more than $14 billion that are spent to educate our youth. And they also think that's an underestimate. They think it's more than that. Plaintiff states rely on these funds, and they would be unable to replace the federal funding from another source. The results would be catastrophic, they say in paragraph 2, for plaintiff state students from kindergarten through high school. For instance, loss of special education funding would devastate schools and districts' ability to serve students with disabilities. And they continue. They go through how they're doing it. They say that on April 3rd, the Education Department departed from a long-standing and statutorily mandated process by directing that the states complete a novel and unlawful certification that would also place excruciatingly difficult burdens on the plaintiff states. The certification and its accompanying email, this is from paragraph 3, email directive imposed new onerous conditions in order to continue to receive these federal funds, including putting them in a vulnerable position to indicate agreement with the Education Department's new, vague, confusing, and incorrect interpretation of Title VI of the Civil Rights Laws with respect to diversity, equity, and inclusion. See, that's it. They're, as they said in the complaint, the feds are weaponizing Title VI of the Civil Rights Act of 1964. Because if they're taking a ridiculous interpretation of it to try to eliminate diversity, equity, and inclusion. Here's what the states in their new filing said about diversity, equity, and inclusion, just to be clear. And they don't mince words. They say in paragraph 75, or 72, accordingly, the principles of equity, diversity, and inclusion in schools are built into the very fabric of the federal funding formula and civil rights statutes from which states receive the vast majority of their funding. And what they've told Judge Young is all of these things violate the Administrative Procedures Act and the Constitution. Again, a little bit of a tutorial. States are generally using the Administrative Procedures Act, which is implemented by Congress, about how agencies can act. And they have to act in a way that's not arbitrary or capricious. It has to follow the law. It can't be outside the boundaries of the law or contrary to the law or to the empowerment of the law given by Congress. It can't be in excess of statutory authorities. And then they go and say, and in addition, it's Congress that controls the purse strings, not the executive branch. So this attempt to screw with our funding violates the separation of powers. It usurps legislative authority from Congress. It violates the spending clause, the appropriations clause, all with Congress and Congress's powers. And it is ultra vires, meaning it is outside the boundaries of our legal system and law. And they're asking the court to declare all of these things unlawful, to preliminarily and permanently enjoin the defendants and their employees from doing things. They've also filed a motion for temporary restraining order as well. We'll be reporting on all of this, but I think this shows a number of things. First of all, Leticia James is not scared of Donald Trump's threats to go after her for mortgage fraud. Okay, that's one. If anything, it fired her up. But what this shows, of course, is Leticia James is not scared of Donald Trump. She's going to continue to lead the charge just as she did in the first administration against them. And she's got a 900% winning record right now against the Trump administration. It's these groups, the American Civil Liberties Union, Democracy Forward, Democracy Now!, the attorneys general around the country that are successfully pinning Donald Trump back and making him think twice. And it's showing up in the polling numbers that they are successful. It's having not just an effect in the courtrooms. Some people are saying, what does it matter? He's just not going to abide by it. He's starting to abide by it. Maybe not because he wants to, because he realizes politically he has to. He's a political animal. I mean, he's an animal in many, many ways, but Trump is a political animal, and he reads closely the polling numbers. And right now, in the last few days, the polling numbers have been terrible for him. And not just the New York Times and the Siena poll. I'm talking about Fox News. 70% of America thinks he's overreached and needs to stop in every area that's been important to him. That this is not what they voted for, that they think the economy is in the trash because of him, that they would rather have the Democrats run Congress. That's a wake-up call for Donald Trump. This is not what people voted for. And so wins and lawsuits like these filed by the attorneys general are very, very important. You know what else is important? That you are here with us on Legal AF. This is a fellowship, a community, shoulder to shoulder that we're building together. Hit the subscribe button. Help us continue to grow. It's free, but it has a major impact. It helps us bring on new contributors, new voices that you haven't heard before, new information, 10 different contributors, 10 or 12 different contributors, and a video every hour at the intersection of law and politics. The hottest corner right now in our society because of Donald Trump. And I'm here for it. And I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.